Just tell us. Hmm? Why do you need to file the affidavit in reply?
Dr. cannot, sir.
Huh?
My senior instructed me only to say those things which I just submitted in the first half. So I don't know. I'm not aware of it.
You had the file with you.
I had it, but it's a
Okay.
very old case, and
Huh?
it's just 2 months I'm into practice, and it's very new to me, so I couldn't.
This
figure out.
one,
2 months I'm into practice, and it's
so
very new.
you are certified as perhaps Mr. Bhattagur is. The certificate remains the same. License doesn't vary. You want to file a reply. If you're not taking advantage of things being accorded. Miss, your name?
Dev. S. Dev.
As Dev, Learned Counsel, on behalf of.
Huh? He's like
Huh?
He's like
Has submitted that an affidavit in reply is required to be filed. Stop the affidavit in opposition had been filed in the year 2022, and the matter relates to the claim for appointment on compassionate ground. Why do you not consider him?
He doesn't falls under the guidelines. He retired from service after attaining of age of 55 years.
Ah.
He's up to 55 years.
It is?
Up to 55 years. If he retired on medical ground, up to 55 years, his case can be considered.
Mm.
But he attained the age of after 55 years, he retired from service.
What age did he retire?
He retired on
Where have you taken that stamp?
page 54.
54.
This is the order passed by the commandant and in an affidavit. At the time of retirement, his age was 55 years, 5 months, 20 days. We have stated in page 8, prayer number 3.4.
He retired on medical grounds.
Yes.
And there must have been a medical invalidation board. On what date was the medical invalidation board? He was referred to the medical
Yes.
for medical invalidation.
On 2 occasions, he was referred to medical board.
The second occasion when his medical invalidation was accepted.
Yes.
When was he referred to it?
Yes.
What was he serving as? Group D.
He's a constable.
Huh?
He's a constable.
Constable.
His father was a constable.
His invalidation board, where do we find it?
1.
So when
kindly
was
say
he
page
retired?
3,
The year of his retirement is 2017.
Yes. Kindly say page 3
Page 3 of what?
of the affidavit.
Of the affidavit.
Yes. From top is 9th line. Accordingly, the said individual was sent for extending medical board held at CISF so and so with effect from 21/2/15 to 25/2/15, wherein he was placed in low medical category.
Thakur,
Yes, madam.
the next page, the show cause notice is there.
Yes.
You refer to a show cause notice. And he told you on 25/4/2016
Hmm.
that
So-
that he has no objection for his retirement.
Yes,
Now, what was the date on which he was retired?
so it on 3/5/16 with effect from 21/3/2016. Page 54.
P5/16, he was retired.
Yes, with effect from
He made his
21/3/16.
application, the recommendation came on 21/3.
Yes. At the time of
Just a
recommendation,
minute,
he was
on
73.
21/3. And he suffered that paralysis on what day? On 10/8/14.
Yes,
Is it not?
yes,
So from 14 to 16,
yes,
you have consumed the time. You could have retired him on 14. The delay is of 5 months.
yes.
Kindly have your instruction.
Obviously,
When your processes took time,
because he was placed in the rehabilitation board also.
could be,
Yes.
you had to follow your process.
Yes,
There was no time bound limit to it. Only time bound is a few months where he gets to place in a representation challenging the
Yeah.
same. He did not challenge anything. So the condition remains. Had you taken up the rehabilitation board immediately when he suffered paralysis, he would be well within the age. The consideration is
Yes.
for compassionate appointment,
But
for
it-
appointment on compassionate ground.
but at that time also he was a minor.
Who?
Submit the petitioner.
So when did he apply?
He applied on,
How late?
yes,
See, madam, these are things which you could have told us. The dates. If not anything else, you could have gone through the dates.
he applied on 20th of December 2016.
Now, so he was a,
This is within the time.
had it been at that point of time,
Yes,
he would have been a minor, see,
yes,
but the right to be considered would remain.
yes,
He could have applied when he is a major. You could have rejected him saying that, okay, 2 years have passed. At that point of time, this 1 year, 2 years, 5 years was not in play. He's an educated boy. He would
obviously.
be vying for 5%
Yeah.
of the entire
Yeah.
post being advertised. You're not promising him anything.
No.
He goes through the entire recruitment process, the physical part of it,
Yes.
the medical part of it, everything.
Yes,
It is your man serving in the force
yes,
who fell down when he was on duty.
Mm.
Is it not?
yes,
So on duty, then he would also receive some last few cases, 1 case or 2 cases before we have seen. What was that? Gracia, ex gratia for
Yeah.
having been thrown out of service.
I will also take the instruction.
Just find out the date when the incident occurred is within 55 years.
Yes,
Time consumed is by you,
Hmm.
is by the department. Is it not?
yes,
He applies within that 1 year period.
yes,
So giving him an interview call letter for 5% of the vacancies,
I understand.
you're passing an order at a later date. Would it take away his right? Huh? Is again on, when do you, by when can you file the affidavit, madam?
2 weeks.
2 weeks. You have dated ready for 2 weeks also.
On 18,
18,
yes,
18th of February.
yes,
18th of February. After 18th, if it's possible.
19th? Okay, 20th to 20. 28 বহুত আছে তেতিয়াহ'লে। তেতিয়াহ'লে 23তে পাওঁ, 23 নোৱাৰি। 23 এফিডেভিট ৰিপ্লাইখনে ফাইল কৰি। Mr. Borthakur, when a council appearing for Mr. S.S. Roy shall inform Mr. S.S. Roy that regarding the queries raised by this court,
yes,
the instructions to be taken. Huh?
Yes, obviously.
The matter relates to consideration for appointment on passionate ground when the father of the petitioner had been retired on medical grounds. Yes, next.
Hi, Vinay.
Yes, Mr.
Worship, here in this case, on the last occasion, Worship remembers there's a.
Well, I have an instruction, Mala. Actually, on 3rd of February only, the directorate has received the selection committee report, Malad. Report from the selection committee in connection with the appointment, Malad. And now this is under process, Malad. Just to go through it.
Tell us when.
After 1 week, Malad, 20, Malad. Around 20.
1920, we can forget 23rd.
23rd.
This is, they will file the affidavit or they will clarify the.
No,
The
they, have,
affidavit
they say they are examining the report which has come from the college,
Okay.
from the selection committee as to why the marks was given and why the marks was not given. Either which ways. So on 23rd, if they do not come up with a proper
Actually, selection.
solution,
So if you kindly see the last order, in the last order, it is for the selection committee to clarify the thing. They have not clarified. They are
what had
delaying the
happened,
matter
Malad?
for no reason.
The directorate has asked the the college authority to review their proposal,
They
Malad.
have not done it.
They have done, Malad. They have done and they have.
no.
We have
We had
received
said, we had said to place before this court report of the selection committee received through the principal.
Yes, Malad. The
We need
report.
the report.
Where's the report?
It was supposed to be placed before this court. There might
Exactly.
have been a misunderstanding on your part of the order.
Maybe.
Now we have read the order to you. You can verify it again.
Alright.
Call for the record. Call for a copy of the report.
I'll place then on next.
Scan copy, you call
Yes,
for
yes.
it now.
Yes.
Give it to us. We'll say that it has been produced. We'll allow the higher education to take a call on it. Let us see the report.
Yes.
We'll not pass any orders on the report. It is for you to take first a decision.
Yes.
Call for the report. Total episode not okay. Have a scan copy of the report.
I'll call, Malad.
Huh?
I'll get it, Malad.
Please get it. Please get it. We'll just go through it that the report is there.
The
What is
report
the
sent by the
probable
college
line
authority.
taken,
yes.
huh?
The report sent by the college authority.
Ah.
Yes, yes.
Lordship,
That
the
is what you're
interesting
asking.
part is that, Lordship, even after the receipt of this, the notice of this honorable court,
Ah.
the college authorities are not appearing. They can appear before this honorable court. They can clarify the entire aspect of the matter. For last so
It
many
will be
years,
to
the matter is
It will
pending.
be to their peril, sir.
Yes.
It will be to their peril.
Hmm.
For college authority, we don't appear, Malad.
Huh? We'll have it after some time.
Yes, yes.
বেয়া, গম পাইছো, মই লিখি দিছো। তাৰপৰা কপি কৰি ল'ব। Next one.
Here, my
Hmm.
due to arrest of the petitioner in connection with a criminal case, my lord, I was, my lord, suspended from service, my lord, and subsequently, my lord, after release from bail, my lord, I filed an application for, my lord, reinstate in the service, my lord, but till then, my lord, I was not reinstated, my lord. And on the other hand, my lord, the suspension order was also, my lord, not reviewed within 90 days, my lord. That is also apparent from the, my lord, last occasion. my lord.
What are your instructions?
My instruction, my lord, is that after the first suspension order, my lord, no review has taken place.
There is no charge, no memorandum of
Charge
charge.
sheet issued.
When was it issued?
Charge sheet has.
It was, my lord, page 28, my lord, 6/11/2023, my lord, but in the charge sheet also, my, it was, my lord, not, my lord, accompanied with the, my lord, review order, my lord.
Not, I'm not.
Charge
I
sheet, my lord,
reviewed
page
it.
28, my lord, I have an example.
28.
So cause, my lord,
So, cause, yes.
page 28, my lord.
But there was no review done prior to that.
Lordship.
When were you suspended?
I was suspended, my lord, 6/10/2023.
Have you been reinstated now?
No, my lord.
It can be, my lord.
Huh?
Reinstatement can be done because review has not taken.
The thing is, when the law is clear,
place.
the instructions have been provided to you. Why have steps been not taken on the by the department itself?
That is something even, my lord, I'm also
Yeah,
wondering.
the department wants the court to pass order in all cases. Who is the person who is required to reinstate or review?
Reinstatement, executive engineer. ma'am.
Executive engineer. Down heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. So-and-so learned counsel appearing for the THE
THE.
department, full stop. The gist of the case is that the petitioner had been arrested on the basis of an FIR lodged before the officer in charge of the ACB police station Guwahati on 4/10/2023 with the allegation that the petitioner had demanded ₹10,000 for providing contract license. The petitioner was arrested on. Yes, sir.
Petitioner was arrested on, my lord, 5/10/2023, my lord.
On 5/10/2023 in a trap case.
Page 23, my lord.
In a trap case.
Trap case, my lord. Trap case, my lord.
In a trap case and was remanded to custody. The petitioner was therefore placed under
Suspension, my lord.
deemed suspension for having exceeded a period of 48 hours
Lordship.
in custody. Full stop. The deemed suspension came into effect from 5/10/2023 itself. The show cause notice was issued to the petitioner on
6/11/2023.
6/11/2023. The petitioner was released on bail on
16/11/2023, my lord.
16/11/2023. And she submitted her show cause reply on 29/11/2023. The present status of the disciplinary proceeding is not placed before this court.
Yes.
The learned counsel for the petitioner has also failed to punish the details of the stage of the disciplinary proceedings initiated against the petitioner. Next paragraph. On 18/11/2023, the petitioner had filed a representation praying for. What is this page 8, para 8?
What my lord represent?
Prayed for a? Prayed for?
Minister in service.
Where? Prayed for
It should have been reinstated.
instead.
Answer, my lord.
Prayed for reinstatement in service, but the same has gone unattended to. The period of 90 days from the date of deemed suspension would expire on
That instruction I do not have, my lord, but from the order, my lord,
5/10/2023, kindly count 19 days, 90 days.
It will be on 6/1/2024.
6/1/2024. In such date, the suspension order, the competent authority did not review the case of the petitioner with regard to the requirement of continuing the suspension during the period of the departmental inquiry or the pendency of the criminal case. The learned counsel for the petitioner has submitted that although a charge sheet has been served upon the petitioner and the department proceeding is ongoing, comma, there was a mandatory requirement on the part of the respondent authorities to have reviewed the case of the petitioner and passed orders either extending the suspension or of revoking the same. The learned counsel for the petitioner has submitted that it is settled position in law that in case a charge sheet is submitted,
2015 7 SSC 291.
but even in the event that a charge sheet is submitted, comma, the departmental authorities would remain liable to review the case of the petitioner for suspension.
Para 21, my lord.
Para
20 and 21, my lord.
here we go. Person. Ako pa po. Even in case the charge sheet is submitted, comma, the respondent should remain liable to review the case of the petitioner and decide upon the requirement of continuing the same. So he has referred to the case of Ajay Kumar Chaudhary versus Union of India, reported in 2015 7 SC91. The learned counsel for the respondent has clearly submitted that as per instructions received by him, there is the case of the petitioner was not taken up for review of the requirement of keeping him under suspension during the period of the discipline or of the criminal proceedings against him. In the light of the settled position of law, as observed in the case of so-and-so versus so-and-so by the apex court, reported in so-and-so, the suspension order does not survive beyond a period of 90 days from the date on which it is issued or deemed to have come into effect, unless the same is reviewed. In case the in case of deemed suspension, as held in the case of Deepak Mali versus Union of India, the period of 90 days is to be counted on and from the date on which the petitioner is released on bail, or on and from the date on which he informs the department about his release on bail, whichever is later, earlier. Full stop.
Later, it
Whichever
will
is
be
later.
later.
Whichever is later, full stop. In the present case, even if it is assumed that the department had been informed about the release on the petitioner submitting his response to the show cause notice, the order of suspension having not been reviewed till date cannot survive beyond the particular period, full stop. This court also cannot lose sight of the judgment and order of the apex court in cases Sareen versus Union of India, which dealt with the cases in which allegations of corruption were leveled against serving employees of the government, full stop. Therefore, in the present case, this court interferes with the continued suspension of the petitioner only on the ground that the period of 90 days had lapsed before a review has been conducted of his services, full stop. The petitioner is required to be reinstated in service forthwith. However, the department shall be at liberty to consider and pass necessary orders regarding the requirement of restraining the petitioner from attending official duties at the place of occurrence and of reposting him to some other location if so necessary to aid the completion of the disciplinary proceeding, full stop. The department shall keep in view the fact that there was also a criminal proceeding pending against him, and if any such proceeding is actually pending against him, petitioner should not be put to a disadvantage in case his place of posting is changed. The repetition is accordingly disposed of. No costs. That we will not observe now. What you do with the period in which he was kept under suspension, it will come up in the disciplinary proceeding or the criminal case.
Obliged.
Only peruse the last order dated 19/9/2020.
Your assistance is required to tell us the gist of the order. Our perusing, it will take a long time.
Yes, Malad, gist of the order is that the Honorable Courts is directed to constitute a board for medical examination of the petitioner ballot, and the report has to be submitted before this Honorable Court.
What was the defect in you?
Malad, a color vision.
Yes, madam, color vision.
Yes, Lordship.
Person from the black and white era, why are you?
He was rejected on the ground of color vision, Lordship, and provisionally he was appointed provisionally, Lordship. After that,
Tell us the result of the review medical.
defective color vision by 6 point.
You are Jiten Narayan Das.
No, I'm Shuman Das.
You are?
Shuman Das.
Oh, your father is Jiten Narayan Das.
Yes.
There is no secret in this. No. It the petitioner. Kindly, Mr. Gogoi, kindly share with him. In case he does not understand the abbreviations, kindly.
Yes.
Deficiency is in green and red color.
Green deficiency, red and green.
Do you know what is defective color vision
Yes.
and why it is important? Hmm? Do you know why it is important?
Yes.
Why?
Because the defective color vision, he could not recognize a body mallet.
No. Defective color vision is when you cannot differentiate the blur in
Yeah.
color. Therefore, if someone is wearing a camouflage, even if he's running around, you will not be able to notice him. It is not that they will ask you to identify yellow and you cannot identify yellow. No. Within green, they will write in blue 6.
Yes.
You cannot identify it. So therefore, when you read a map, when you need to go for an operation, you will not be able to know where to shoot, where to go. No one will have the time to instruct you, go here, go there. They'll give you a map. You will not be able to read it. 1, 2. There is a benefit of being color vision, defective color vision. They can identify khaki anytime. And they were used by Japan, they were used by the UNO during the World War for identifying Japanese troops. They used to wear khaki and wear not traceable. Colorblind people were taken on helicopters. They could identify very easily where the khaki fellow is sitting. Heard Mr. R. Islam, learned counsel for the petitioner, also heard Ms. S. Bora, learned CGC. Mr. B. Gogoi has appeared on behalf of the medical board, being authorized by the Director of Health, State of Assam, which was requested to carry out a medical board of the petitioner with regard to the allegations that he has defective color vision. Full stop. The earlier order of this court of 19/9/2025 reflects records as follows. You take from the first paragraph to this whole page, both sides. The first page, both sides. Full stop. Mr. B. Gogoi, learned additional Advocate General, Public Standing Council Health, has placed the report of the review medical board before this court, which shows that the petitioner indeed does suffer from defective color vision. Full stop. Since a board of specialists in ophthalmology has opined that the petitioner suffers from the defect traced during the review medical board of the respondent authorities, this court cannot proceed to grant the reliefs prayed for in the writ petition. Accordingly, the prayers are rejected. Writ petition is closed. The report of the medical board constituted by the Director of Health Services is kept on record and marked X.
Much surprised.
Yes, sir.
In this case, I think Sarvasiksha Abhijan has to.
There is awaited.
What is awaited, sir?
Instruction, let it be after 3 weeks.
What
was the matter?
The issue is that, my lord, the petitioner was a CRC, my lord. His duty was to visit the schools and send by internet the reports. The ID that was taken back, but not withdrawn from the petitioner, but that was not given to him. And accordingly, whenever he visited their office, they, for discount or that count, it was refused, my lord. One day he was transferred, my lord. On that transfer order was challenged. On appeal was filed, the appeal was not disposed of, then a writ petition was filed.
Writ petition directed that appeal should be disposed of.
Hmm.
The appeal was disposed of, holding that the transfer is good.
Hmm.
That was challenged before this court.
Uh,
Then court came to the conclusion that wherever he was working, he is entitled for salary. And he has to pay the salary. He has to receive the salary. After that, it was the order of 2023. After that, my lord, till today,
hmm.
he is nowhere, my lord. He is neither allowed to work as because the ID has been provided to him, it has been withdrawn, and no salary has been paid, my lord. Now the Sarva Shiksha Abhiyan has to file affidavit, my lord. This is the third round of litigation, my lord. In the meantime, RTI applications were also filed and personal hearings also took place. But that personal hearing results, those are also not given to him, my lord. And he is now,
Yes, sir.
2016 melody is not there, from 2016 onwards.
Uh-huh.
But I will have the melody.
No, but he was
Given a
going
hearing in
around
2024, I
Huh?
suppose. In 2024, he was given a hearing.
Hmm.
I will place everything on, let it be after 3 weeks.
He's awaiting his salaries.
Yes. ma'am. No, he is not rendering any service also, madam, so far as,
But you say that he says that you have withdrawn the ID, therefore he cannot log in.
yes, yes,
so
Then
he
it will
was,
be at your peril
yes,
unless you show that his ID had continued.
lordship. But,
How
attendance
is
and
the
all-
ID withdrawn?
I don't know, my lord, because he was.
He cannot log in with his ID.
Yes,
Probably suspended, madam.
Huh?
Or,
So kindly find out when was the ID suspended.
lordship.
Kindly find out whether it was reactivated. If so, when?
My lord.
With some, there must be some
Yes.
authorization to reactivate it.
My
Simply reactivating it today, saying it was reactivated 5 years ago, neither you will be able to find out now. But there must be some authorization.
Yes,
Please
yes.
reactivate the ID.
Lordship.
So those two are the documents. If it has been activated and he has not used.
Otherwise also you will have to render his services, not that my lord, he will have to log in, my lord, anytime.
Huh.
So that part, whether he has attended the office, whether there
that
is any
report I have
attendance.
submitted, my lord. They are
Where?
before the district officers.
Who gave you that report?
I was asked to place the reports whether I worked or not. Accordingly, I had submitted it, my lord. Lordship may come to page number 84.
Hmm?
Page number 84.
'84.
84, my lord. Data dated 12/9/2023.
Hmm.
Issued by additional district commissioner, my lord. Come district mission coordinator, Sarva Shiksha, my lord. In reference to your letter dated 3/8/2023, pursuant to the decisions, directions passed by the Honorable High Court dated 27/2023 in WPC 5659 and as directed by MD, you are hereby directed to submit your working report to us as directed for the period as described in the order dated 27/2023. Thereafter, my lord, in response to that, my lord, at page 88, my lord, I had submitted the report.
No, you had submitted a report saying that from January 2026 to October 2018, you discharged your duties.
Yes.
Thereafter, because you did not receive any instructions, you did not discharge any duties. You are not in a position to
Yes.
discharge any duties.
Yes.
16 to 18, you have been paid.
No,
Why not? Mr. Gogoi,
Page
There is an order.
73, page 73.
the
Lordship,
last
see that?
part.
Yes, ma'am.
So 16 to 18, he has said that I have worked.
No, 16, madam, from March 2016 to December 2016.
March to June, it will be
Subject to submission of report, working.
He has submitted a report, you have not said no. Then January 16 to March 16,
January to March, yes.
this order was of 2023.
Yes, ma'am.
Why did you not ask for the rest of it up to 2023? Why did the not court grant you that part?
Because, my lord, there was a stay order, status quo order. Court observed that status quo order was not extended later on. For a particular period, it was there, my lord, because he was transferred to a place where he went to join, my lord, there somebody else was working.
Mr. Gogoi, kindly have instructions whether page 73, para 23 has
Yes,
been complied.
23 has been complied with.
Number one. Number two, this came to be disposed of in 23. Now, in view of the application submitted on page 90,
Yes.
on page 90 at the top, we find some signatures and the hearing that has taken place.
That's it.
Hmm?
My lord.
Heard Mr. So-and-so learned counsel appearing for the petitioner also heard the the petitioner also heard Mr. B. Gogoi learned standing counsel SSA. Full stop, the matter relates to the non-payment of salary to the petitioner, full stop. By an earlier order of this court, the respondents were required to consider the payment of salary to the petitioner vis-a-vis the period already recorded in the order dated. Where is that order, sir?
Hello?
Which we were just reading, that order where you were required to pay the salary? Or you are required to be paid the salary?
73, my lord. Page
So,
73.
what is the repetition number? WPC 5696 of 2016.
Order
Order
dated is 27, 20723.
Order dated 20 July 2023. है ना? Full stop. The learned counsel for the petitioner has submitted that the petitioner had submitted the working report by the letter dated 15/9/2023, page 90. And hearing was also held on
10/4/2000.
10/4/2024.
2024.
2024, full stop. Huh?
10/4/24.
10/4/24, full stop. Till date, the outcome of the
Yes.
hearing is not available. Full stop. Learned standing counsel shall have appropriate instructions on the next date of listing on the aforesaid issues. List again on
After 3 weeks, my lord.
5th, 25th,
That's it.
25th of February
My lord.
25th of February.
2026. Since the matter relates to the payment of salary, it is expected that the respondents should have their instructions placed before the learned counsel.
As regards the ID, my lord, that
The learned standing counsel shall also have his instructions as to whether the ID allotted to the petitioner to serve as a CRCC was indeed suspended, and if so, was it reactivated, comma, the order by which it was reactivated and the order by which it was communicated to the petitioner. This is item 20. Yes, sir.
May I appeal, Lordship?
Lordship,
In this case, Lordship, the petitioner's case was not considered in provisional release, Lordship, provincialization. In spite of Lordship fulfilling all the requisite criteria, Lordship. This is Lordship third round of litigation, Lordship. Earlier also, Lordship petitioner approached before this Honorable Court, Lordship. And Honorable Court was directed to pass a reason order, Lordship, within 2 months, Lordship, and thereafter, Lordship.
yes, who appears for the education? Elementary education.
In order is at page 17, Lordship.
There is a saying in English, now you see me, now you don't. Now I can see them, now I cannot. You have Standing Council Elementary Education, scroll 30. After some time, let somebody be here.
Small matter, lordship may dispose of the matter, otherwise. But here, this affidavit, they were supposed to file my letter here. Just I would like to clarify before lords. In earlier occasion, they file an affidavit by misleading my representation, 2015 representation.
It is a case for what?
This
Compassionate
compassionate
appointment.
appointment. Compassionate appointment. And my letter, in earlier occasion, they have rejected my proposal saying that since the father was expired in 2016, so in 19 we have got the proposal. So after 4 years, it has been rejected. Immediately in 2015, the application was submitted, that was not considered, and that they have concealed it. Then when this honorable court directed to bring the record, and subsequently they have filed an affidavit saying that yes, that 15 representation is available, and whatever the concealing part in 2019 they said lordship will find the grounds they have stated, my lord. They conceal it, my application, my lord. Lordship will find the relevant portion of the DLC, my lord. Page 43 starts from 43. Relevant portion (44) and minutes lordship will find the ground 46. 45, 46, my lord. 46, 29 serial number. Navajit Bhagavati. The married.
Why don't you vie for the posts which are there for physically handicapped person?
Physically handicapped.
But
That
are you asking for a reservation within the physically handicapped, within the compassionate appointment? 5% is there,
yes,
4% reservation,
reservation.
4% for physically handicapped.
Yes.
Out of 100 posts, 5 would be there. Out of that 5, 4% would be what?
My lord,
Or should the attempt be for a direct compassionate appointment? We are not convinced that we can allow this to continue. Supreme Court has been clear, our High Court has been clear in the writ appeal.
no, in the writ appeal also. But recently in the Supreme Court also 2025, Canara Bank, it has been said regarding lapse of time, lordship is saying, or
Yes.
delay.
Lapse of time.
The Supreme Court has said in para 25, the Canara Bank, my lord, 2025 reported, my lord. It has been said that delay factor will come only from, if the petitioner file his application beyond the period of that is suppose 1 year.
We are not on that delay, sir.
That's it.
We are on the delay of 10 years having passed.
No, there are also some decisions of this Supreme Court, my lord, in 2024. Even 15 years, this grounds was taken. Then Honorable Supreme Court says, no, that cannot be the ground.
Have you filed the clarificatory affidavit, sir? You appear for the PHE?
I apply for the elementary education.
Why are you here?
Because I've been made a party, my lord, party respect number.
Board con change हुआ नहीं तो item क्या मत इसे 21
21 नहीं है।
this is item 21 20 we have kept for a time being. Okay. But Mr. B. Chetty, Learned Counsel appearing for the petitioner, none appears for the respondents when the matter is called for. The affidavit as required by the order dated 10/12/2025 is not on record. There is no counsel to represent the department before this court today, full stop. Admit the petition, placed again on March order date the auction.
Let some other decisions are there, but
It
this
is-
decision
Judgment.
is also
March
important.
order date the listed in the hearing column.
Very
Hearing date the
Very short order.
Huh? The learned counsel for the petitioner has submitted that this particular, this case would require a consideration. The basis of the judgment delivered by the apex court in the case of Govinda Janardhan Gaikwad versus State of Maharashtra and others. Decided on 6/11/2023 and this again on the 5th of March 2026 in the hearing column. For hearing column, full stop. You give this back on. The absence, you are appearing for the PhD department, madam?
PhD, I'm not appearing, Lordship. They have separate standing counsel, Lordship.
Yes, sir. 5th of March, we'll take up the decisions
Yes. For disposal, lordship will say.
in the
Otherwise-
hearing column, we have
Yes.
said. So we'll hear it. Elementary education.
Can it be for further hearing, my lord?
It will come up for hearing. We do not know whether we are here or not.
No, that's why, my lord, I thought, my lord,
In the hearing column,
hearing.
because two judgments have to be evaluated, Devabrata versus whatever you have placed. Any court can do that.
Even after Devabrata, my lord, there are 3 or 4 judgment, my lord. Even 3
All of
judges,
them, have all of them.
even this Canara Bank 25. My lord, I have seen, my lord, I'm not arguing, my lord, otherwise, just for your lordship's information, my lord. Since I have gone through all this judgment, my lord. And it has been said, it has not been referred the Devabrata Tiwari's case in all other subsequent cases, my lord.
Devabrata Tiwari has not been referred.
Not been referred. And rather, even 2001 cases, which were the father died in 2001 and 2, their cases has been considered on merit. This Devabrata Tiwari case has not been referred. This is the interesting point, my lord. I'm obliged, my lord. I'm sorry.
Yes, sir.
My lord,
May it please your lordship. Morning, I made a prayer that the matter should be adjourned and I have received the instruction. Lordship,
Here it is a case, my lord. The petitioner, my lord, he is a chief medical officer in the Border Security Force, my lord. Equivalent to commandant, rank of commandant, my lord. In 2022, a combined senior release of all the medical officers of the Central Armed Police Forces was prepared, my lord, by the Union government. In that combined seniority list, some of the juniors were placed above the petitioner in the graduation list, my lord. That graduation list I'm challenging, and the rule say, my lord, the rule is very specific in the of the Border Security Force Service Rule, my lord, that the seniority shall be determined according to the merit position.
Understood.
That is the law.
They have placed an instruction before us to the effect that the board of officers has been detailed by the ADG Medical to recommend refixation of seniority.
My lord.
A board of officers has been detailed to recommend refixation of seniority.
My lord.
Part of your grievance is being addressed by them.
My lord.
They are recalculating the entire thing. So we can allow them, how much time do you need?
4 weeks time, my lord.
Huh?
4 weeks time.
Why are you reducing what they have already asked for? They have asked for
Mm,
6.
I know, my lord, 6 will be not possible, so I am praying for 4 weeks time.
Mr. Swensel, Learned Counsel appearing on behalf of Mr. K. Parashar, the learned CGSE has placed before this court an instruction by which which reflects that a board of officers has been detailed by the ADG Medical CAPF to recommend refixation of seniority in respect of medical officers, including the petitioner. Full stop. The proceedings as per the instructions are in progress. Full stop. Though this court is not impressed by the reference in the aforesaid instructions regarding approval of competent authorities as a ground to allow further time for filing of the affidavit, since the board of officers is looking into the issue raised by the petitioner herein, place this matter again again on March or date?
My lord, a prayer after 4 weeks.
On March, we are taking it up on March.
Fixing the date, my lord.
9th or 11th, Parajan? 6th of March,
16.
2026, by which time the respondents would ensure filing of their affidavit.
How long?
20. Being, I think, 20.
Lordship, in order is at page, Lordship, 17, Lordship. Earlier, the petitioners approached before the Honorable Court, Lordship, and Honorable Court passed an order, Lordship.
Just a minute. Huh? Additional affidavit filed, sir?
Lordship, I filed my affidavit in opposition.
When?
Lordship, I filed it on
Have you gone through the
25th
order
April.
passed in this case?
25th April, my lord.
Okay.
Lord, it was regarding provincialization, my lord. And
What is the ground of rejection?
non-fulfillment of criteria, my lord,
Which criteria?
as per section
Enrollment.
314 of the 17.
Huh?
314 of the 17 Act, my lord.
What is the criteria?
Enrollment criteria, Lordship.
So
314, yes.
enrollment criteria.
Enrollment
You don't
criteria.
have the requisite number of students.
Fulfill, Lordship. Kindly see, Lordship, at Lordship, page 36, Lordship. It is the physical verification report of the authority, Lordship. Last occasion on Lordship, 5th June, Lordship, the Honorable Court also directed to the authority to file rejoinder affidavit, if any, Lordship. On this
Tell
point,
us,
Lordship.
where is the ground for non-fulfillment of that criteria? Enrollment of Bodukpara was found to be Bundukmara.
Yes, Lordship, Bandukmara LP School. Purvapar VLP School.
They have 28 and they require 30.
30 minutes. As per
Yes.
314. At page 36, Lordship, it is the
At
status
page-
report.
Just a minute. Page
36, Lordship.
name.
It is,
Names have
Lordship,
been done.
submission of report in connection with enrollment status of Bandukmara Purvapar VLP School. At page 36. Your Lordship, the authority stated that, Lordship, as per portal report, Lordship, our enrollment is, Lordship, 28, Lordship. But Lordship, when the authority, district authority submitted their minutes, Lordship, for provincialization of the schools, Lordship, they have admitted that, Lordship. Finally see at page 30, 30, Lordship, this is minutes, Lordship. Here it is, Lordship, clearly stated that, Lordship, in some remote areas, Lordship, the CRCCs could not be able to upload the actual portal in the portal device.
Why?
For Lordship, some due to some technical defects, Lordship. It is
So they
stated-
gave a wrong number.
Lordship,
So they gave wrong numbers.
no, Lordship, as such, Lordship, they have not uploaded properly.
The CRCC are teachers who are deputed to do certain work. Is it? Who stands for the SSA? Is SSA a party here?
My lord, SSA is a party here.
SSA is a party here.
Yes, my lord.
None appears for the respondent SSA when the matter is called for to clarify the queries of this court. Full stop.
Respond.
The mission director, SSA to level, to remain present personally. Yes.
Mr. P. Naik for
Ah.
he's on legs in another.
Is there only one counsel appearing for the SSA?
Today this matter has been brought to Mr. P. Naik.
When would he have been available?
He's put in on legs.
Kindly have your instructions or have it allotted to someone else to appear before this court. We'll take it about 15 minutes. And when this matter was called, when we ask for a personal presence, then your personal presence suddenly appears. Is the code? I saw you run from there. The smile would not allow things to be taken lightly. Have someone attend the court, have some instructions as to who is the CRCC, why was it wrongly uploaded, under what circumstances, that the SSA has to answer. The DEO is saying they have 31 students. The SSA is saying they have 28 students. Matter of fact, we can send it back to the tribunal to sort it out. Someone is lying somewhere. Who? Didn't it? Have your instructions. We'll take it over 15 minutes.
24.
My lord, the petitioner appear in 2024 examination, my lord. Subsequently, my lord, this petitioner again appear in 2025 examination. And my lord, he remains successful, my lord, in computer, physical, my lord, other eligibility, my lord. Within the February, my lord, there may be, he may be appointed, my lord. So matter may come on the first week of March, my lord.
There is a scope that he may be
Yes,
appointed.
Yes. Character
what
verification
your-
is going.
Instructions are.
I have filed my affidavit in this matter.
Yes.
That's fine.
And in that you say that we will not give him the appointment.
Yes, he produced invalid OBC certificate, Lordship.
Then how do you expect?
Not obviously,
ABC certificate, crucial date is in, as
Economic
per our
quicker
advertisement.
section certificate.
So now why do you expect that your name, you'd be appointed? They are saying the certificate is wrong.
No, Lordship, kindly come to page 18, Lordship, 6.3.
Page 18 of what?
Of writ petition,
Ah,
para 6.3, point number 6.3.
closing date for receipt of online applications. Yes.
Crucial date,
We have seen that. So where
Yes.
is he wrong?
he is wrong. He submitted that after produced the OBC certificate issuing after that crucial. date.
Not the OBC.
Not obviously.
Economically
Sorry,
weaker
EWS
section.
certificate, yes, Lordship,
Now a person is economically weaker section today.
yes.
Could he have been economically stronger 6 months ago? Is it not something? Extraordinary, Lordship.
That certificate is only issued for validity period is only 1 year, Lordship. Which
From a
he
particular
submitted.
date to a particular date.
Yes, Lordship,
Now, if it is issued today,
yes.
does it take away yesterday? Is what we are asking you.
No,
Today I am economically weak.
yes. No,
Could I have been
He
economically
produced-
strong?
he annexed two
Where is that?
BC certificate.
Page
Okay,
58.
EWS certificate.
Page 58.
Page 50,
Yes, Lord.
58.
58.
5.8, he does not produce that.
Just a
It
minute.
is
When is the last date for accepting applications?
1/1/24.
31/12/2023.
Yes, yes,
They are
this
extent, not, I have not produced the
according-
certificate of 23-24. I produced 24-25. Their
This-
extent.
uh,
My
our-
submission is that I produce certificate 23-24 as well as 24-25. And both
this
are
certificate
58-59.
So from where are you saying that there is a scope of your appointment in the face of the?
Not in this petition, my lord. Subsequent examination, this is 20.
The learned
Or my
counsel
lord,
for the petitioner has submitted that there is a probability that the matter may not require adjudication in case the petitioner succeeds in
Next recruitment.
subsequent
2025
selection,
examination.
in a subsequent selection
Yes.
process. Full stop.
Yes.
Accordingly, he has prayed that the matter may be adjourned for a month.
My lord, March. in the
For a
March-
month, list this
first-
matter
first
again
week
on
of
the
March.
19th of March,
First week of March any day.
last week of March, 27th of March, sir.
Yes.
27th of March, huh?
Published.
একটু ওরা এসিটা বড় পাইনি, গরম হচ্ছে।
May I please, your lordship, it's a matter regarding that A&M NARS lordship. They are working about, temporarily working about two decades long. About 20 years they are working. Still they are not permanent. But because lordship, they are has all eligible quality. They are also technically qualified. Also, they are working in a permanent post. But they are not. It is our argument, lordship, kindly see. Para 7, I write clearly, lordship, that the petitioner
What is there
respectfully
stand in the
submitted,
affidavit in
as
opposition?
per the law, they are entitled for recognition. 7. Page 9, lordship. That the petitioner respectfully submit that as per the law, they are entitled to recognize of their A&M service, though they are working temporarily, contextually since the year 2006, lordship.
Did they complete 10 years of service?
Lordship, the learned.
If they have now completed 20 years of service, then in 2006, definitely they must have completed, or they have started in 2006. Why did you allow them to work?
Lordship, the learned counsel appearing on this matter is not present today.
Who?
The Upamanyu. Due to some personal reason, actually, his father's health was not good, so.
They are stated also there in affidavit, lordship.
What
Very
do they
clearly
say?
written they have. I see, lordship. It says some persons working for long time would not mean they have to create a right for regularization. But it is totally denied, lordship. In our Supreme Court judgment, lordship, not only single judgment, one is the Joga and Union of India, recent 2024 December, lordship. Another is Dharam Singh versus State of UP,
Heard the learned counsel,
2025.
heard the learned counsel appearing for the petition. Is so-and-so learned counsel representing Mr. Upamanyu has submitted that he is not in a position to appear today. Stop. Admit the petition. List again on.
Lordship, 13,
uh,
can it be fixed on 13
of February.
February?
10th of February. It goes to 25th of February, 2026.
Like,
Two to 34.
34, 33, 34.
33, 34. Yes. What is this matter?
Matter, my lord, a
Small issue
pension,
that-
CPF.
Huh?
Compassionate family pension.
Ah.
Actually, they died 32 after NPS
33 before NPS and 34 after NPS also.
Hmm.
So here, what happened, my lord? Petitioner died in harness. This one 32.
What is their stand?
In the last order, my lord, dated 27/1/26, P. Nayok Lan, Additional Advocate General, submitted the matter as taken up, and he's supposed to appraise the court.
Which, 5627 to Kuntu, Sansun? 5627 case.
56 last one, my lord, 34.
Which is the department? Yes, the Nayak. Yes, Mr. Nayak, there is a order of 27-1.
Yes, court directed, honorable court directed me to furnish the the notifications, lordship.
That was one interesting question that had come to our mind.
Yes,
We found it interesting. It may be very easily soluble.
lordship, even persons who are getting new pension scheme, lordship, in their cases also, family pension or compassionate family pension will be applicable.
Applicable is, see, the compassionate family pension is in place of the compassionate appointment scheme,
Yes,
not as a replacement of the pension made available to him.
yes,
So it will be applicable.
yes. If the only question is the person died in harness, lordship, during the service period, if he dies, even if he is enrolled under the new pension scheme,
He would still be.
he will be entitled to.
Yes.
But no specific instruction I have received, lordship, so far as the present petitioner is concerned. But the notification they have furnished, lordship.
Can I have that? I think this is
Even about
also an
PTMR.
issue with those organizations which have adopted this scheme from the government of Assam. There are some organizations which have adopted it and refused to give them the compassionate family pension because they are under the NPS and they have withdrawn the amount.
Yes.
If this is applicable, even under NPS, they will get the compassionate family pension after they have withdrawn everything from the NPS.
In fact, my lord, in one of the case, yet of the three cases, one case, my lord, it doesn't come under NPS. Yet, my lord, annuity has been, how it was paid also, I don't know. It was refunded back. It was an old pension scheme, my lord. He joined in 1994 and died, my lord.
So, what is your prayer here? OM dated 27/9/2024. Where is that?
OM, my lord, which case your lordship
No,
taking?
your prayer, 5627.
5627.
There, your prayer is 14/9/2017. You want to be paid the compassionate family pension. We'll look into it. OM dated 27/9/2024.
24, my lord. That's my lord, page, my lord, 53, my lord, an extra 50.
Pension or
Huh?
309 account.
Page
53.
309 account আছে নাই? 309 or হেৰিখন আছে নেকি? Amendment খন আছে নেকি? Pension or হেৰিখন?
Amendment.
Why do you want it post?
Actually, my lord, my plea is that it is otherwise not applicable to me. But since, my lord, but then since I refunded the money earlier,
এইখন নহয়।
but otherwise also, that's why I'm saying there's an abundant caution I've made this prayer, because otherwise
Okay.
my case is not.
Now, Mr. Nayak, just help us. Which part of the OM says that he would be still entitled to the
Lordship may come to page number 3, serial
Huh?
number 3.
uh,
One serial number 2 is that family pension for cases covering death of government servants while in service.
appointed on or after 1/2/2005.
That is new pension scheme.
Ah.
The family pension on provisional basis to the family of the state government employees appointed on or after 1/2/2005 and covered by NPS, New Defined Complementary, who have died in harness since 1/2/2005 shall be governed by the Pension and Public Grievance Department OM number so and so dated 14/1/2016. Lordship will come to the next part. However, the government servants appointed under new defined contributory pension system and died on or after 1/4/2017 shall be governed provisionally by the provisions of as described under clause 1(3)(a) of this guideline and in terms of para 5.9 of Finance Establishment Aid Department's notification dated 14/9/2017. 14/9/2017 is that particular, that initial notification.
It's 31st of October.
2017.
So his prayer for quashing OM 27/9/2024, he has to give up immediately
So
because it does not come in his way. He wanted a quashing of that recovery of partial withdrawals, withdrawal of accumulated pension wealth. and
no,
all.
there is another provision is there.
No, what I'm saying is that his prayer in the if you have the repetition kindly. 5627 of 2025.
Yes.
Prayer will be at page 15. Prayer is at page 15.
No, what I read, it's only a part, Lordship. There is another part, Lordship.
Ah.
If in between, Lordship, the person concerned has withdrawn
Hmm.
his NPS contribution, Lordship, in that situation, this benefit of CPF will not be available to him. That is also a, notification is there. That notification is also
That
there.
notification is which?
This is the challenge I made.
27/9.
Yes, I say it's not applicable to me, but then since they are not returning the money on the basis of this, my lord.
No, there
That's
is
why
no
I'm-
question of returning. Once it is withdrawn, Lordship, it cannot be redeposited, Lordship.
It was
That
already-
is the only condition was there.
My lords, it
He
was-
will have to surrender the amount that has been contributed towards his NPS contribution, Lordship.
Ah,
If she has to surrender.
he has to give it back, only then she
No,
will get
there
his-
is no question of taking it back, Lordship. If in the meantime she has withdrawn, then it is
Oh,
gone.
that is
No, my lord,
Forfeited.
it is a case where it was already deposited before this notification came. And my lord, here is a case, this particular.
You took the NPS, whatever accumulation was there, and
Yes.
before this notification came, you gave the money back,
Back,
they have
sorry.
taken it back.
Taken it back. In one case, I could not return. That is the case of Maimun Nessa. That's the first case. With other two cases, I had already returned much before the notification came in.
Yes, in that case, the money was already with you.
Withdrawn. In that situation,
No,
Lordship,
it was with you. They withdrew it.
no, if it is not withdrawn. Lordship.
You allowed it to be refunded in two cases. In one case, because 2024 notification, they did it prior to it.
Prior to it.
They refunded prior to this notification.
Serial number 9, Lordship.
This is of when? 18. So when they withdrew it,
Lordship.
during the existence of this, when they withdrew it, they realized or they were advised, they surrendered it. Here
Yes.
it is a clause that they would surrender. They in fact surrender it factually.
Yes.
Now, once it has gone back to the coffers,
No, there is no question of taking back, but if it is already there, not withdrawn.
technically correct,
Yes.
that would come in with 2024 notification.
Yes. 2018.
2018 notification says that they are required to give an undertaking that I will surrender it.
Yes.
I am surrendering it. They were paid it. They realized 2018. Maybe not in their knowledge at that point of time, they realized. They surrendered it. You accepted it. The surrender was accepted.
Yes.
So now the clock goes back
If
to
it is
zero.
accepted, Lordship, it cannot be,
It still remains with
anti-clockwise,
you.
yes. In that situation, Lordship will affidavit file kara ase. So let the pension department file their affidavit. Whatever I am submitting, Lordship, it was only on the basis of the notifications I have, Lordship. So far
In
as the
cases,
petitioner is
in
concerned.
cases, we are of the prima facie view that since the surrender has been done before the 2024 notification, 2018 notification only required the undertaking.
Yes,
They surrendered it,
yes,
already surrendered.
yes.
So therefore, their cases would fall. In the third case where the surrender could not be done before the 2024 cases, that we are not making up our mind. What do you say on that?
I'll make a submission on that, madam.
we'll
But
keep
before
that
that,
open.
madam, there is another aspect. In one of the item where I returned the money, there the question of annuity didn't come because it's under the old pension scheme. I don't know how they paid the annuity. They were paying the provisional pension also. Then
No,
I returned
even,
the
even,
money.
even in cases of, even in case of NPS also, Lordship, provisional pensions are allowed.
He's under the old pension.
Pension scheme. How this annuity amount was paid?
They are
that's I
giving
don't know.
annuity.
In that situation, Lordship, no question of surrendering. If he is.
No, I have
the
returned
pensions,
return the money back. Since there's an excess money paid to me, I return the money back. I'm not in.
that
it
will be
is
a
that
different
much.
No,
issue.
he's not carrying the annuity. What he
Yes.
got excess was being returned.
Return.
That was a miscalculation on a particular case.
So that is an old pension
So
scheme. That
under
is-
the old pension scheme, since he's not getting anything, he's getting the pension. Consider that.
That was
That
stopped.
has to be under consideration.
That will be a different issue. That is no question of, I mean.
Okay, heard Mr. M. Dr. Learned Counsel appearing for the petitioner, also heard Mr. Nayak, Learned Counsel.
I'm appearing for,
the Learned Additional Advocate General appearing for the state respondents, full stop. In none of the cases, affidavit has been filed, sir.
No,
None of
this is only the second time, I think.
No, it's come in a number of times.
I'm appearing second
Ah,
time.
The
While
Additional
Learned Counsel is
Advocate
being
General, the Learned Additional Advocate General has submitted. Now has produced the relevant notifications before this court regarding the compassionate family pension scheme, implementation of the compassionate family pension scheme in cases similar to in cases which would which would be relevant in the case of the petitioners before this court, full stop. The respondents are accommodated for a period of
3 weeks at least.
3 weeks to file their affidavit in response to the allegations in the writ petition, full stop. Although the matters are listed together, there appears to be a difference in the facts involved in each of the case. Full stop. Therefore, the respondents are required to file separate affidavits in each of the cases to help in the adjudication of the matter. Full stop. List this matter again on, please pick a date.
Do it in
Sometime in March,
second week, Lordship.
2nd week of March, that will be 11th of March.
11, yes, Lord.
11th of March 2026. Petitioners would be at liberty to file their response to the affidavits filed by the respondents in case time so permits. You know.
Lordship, I think
Yes,
I should take back the instruction, I think, Lordship.
instruction did you file Kidal Banha?
But
But
I-
this-
I-
in the file,
These notifications are already annexed to the writ petition.
Huh?
My lord. These notifications are already annexed to the writ petition.
Let him have his copy back.
My lord. They are next to the writ petition. আপোনালোকৰ copies, I'll give the rest to the copies. Ramsing Trust, na? আপোনালোকৰ কোনটো আছে? Writ petition.
Mota Didu Ram Singh.
Okay, I'll give the rest of it. The copy to you. Keep your letter, Rosh.
I can? Yes, sir.
In
Apparently,
this
the
case, it appears, Lordship, according to the authority, number of students is 28 and the requirement is at least 30, Lordship.
And according to the certificate issued by the District Elementary Education Officer available at page 36,
Yes,
the number of students is 31, 37, and 41.
Lordship.
Now, SRCC is a person who is designated by the Sarva Shiksha,
SSC.
Samagra Shiksha, SSA, from the pool of teachers of the Government of Assam, or from a pool of teachers.
Yes,
We are not. Now, the DO gives a report other than what the SRCC has put in. He makes a submission that due to technical reasons, SRCC did not put up the right figure. Now, if a figure is put up, it has to be right.
Yes,
It cannot be that 3 and 1 buttons are not working, so I put in 2 and 8.
Lordship.
Absurd situation, is it not?
Yes, yes. But his, so far as his representation is concerned, Lordship, according to him, the team did not visit his school, Lordship.
The SRCC, the CRCC team.
Without visiting the school, they put some figures.
And the DO says 31, 37, 41.
Yes,
And therefore, we have a reason to believe what he is saying.
Lordship.
Now, CRCC is a member of the institution of the organization on whom entire provincialization is depending.
Lordship.
He needs to answer this.
Lordship.
It is the CRCC who is to answer this issue. rather than the director or anybody else. And if the director has to
although
file
it's a
an
matter
affidavit,
of 2024 lordship.
if
Yeah.
the director has to file an affidavit or someone else in the hierarchy has to file an affidavit, it has to be after a written communication from the CRCC concerned, not on the basis of the portal. Portal we know, 28.
Lordship.
DO letter not contested by the respondents. It is a letter by the DO. From where does this discrepancy come? It will take away half the litigation in the court.
Lordship.
May I submit one thing, Lordship? As per Lordship, BO's report, Lordship, at page
BO.
34, yes, Lordship, 34, Lordship. On that basis, Lordship, the page 36 was issued, Lordship. In this report,
Understood.
Lordship, as per 34.
Understood.
Yes,
Understood. Is the BO the CRCC?
No, no, Lordship.
No. Is it the person who puts it up in the SSA website? No.
He said that as per SSA portal, Lordship, in this column, Lordship. May I note this, Lordship?
We want a clarification from the CRCC. Why the discrepancy with the district authorities? When your allegation is that the field was not visited, your school was not
It
visited.
is reflecting the minutes, Lordship. So I am,
In the minutes of what?
Lordship, by the DLSC, Lordship, district level scrutiny
Very good.
committee, Lordship.
Where is it?
At page, Lordship, 30, Lordship. And at para 3, Lordship.
Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. P. Nayak, learned additional advocate general, public standing counsel, SSA, comma, Mr. A. Fukan, learned standing counsel, Department of School Education. You are appearing, Ms. So-and-so, appearing for the respondent for the district scrutiny committee. The allegation in this writ petition is that though the school had the requisite number of students required to be considered for provincialization, comma, based on the report uploaded by the CRCC of serving under the SSA, comma, the school was shown to have 28 number of students, and therefore the provincialization was rejected by the concerned authorities. Full stop. Learned counsel for the petitioner has drawn attention of this court to the meetings of the district scrutiny committee, in which it has been reflected that the number that the school, namely Bundukmara,
Purbopar,
Purbopar, VLPS, was it recommended?
Yes, Lordship.
Where do you find it?
At 10, Lordship, para 10, Lordship, serial number 10, Lordship. Page
No,
number
that
30.
a recommendation that this is the school being recommended.
Yes, Lordship. This is minutes, Lordship, by the DLSC. Page 30.
Where the district scrutiny committee had decided to consider the enrollment status as per the field reports submitted by the block elementary education officer and the district elementary education officer, and not as per the portal. Full stop. It appears that the DSC had taken a view that the CRCCs did not upload the actual employment enrollment, and there are also certain shadow area where actual enrollment could not be uploaded due to non-availability of mobile network. Full stop. In the present case, it is seen that it is not a case of non-uploadment of enrollment number, but a discrepancy in the enrollment number between the report given by the SRCC as uploaded in the website and the enrollment as certified by the block elementary education officer Hailakandi and the district elementary education officer Hailakandi. Full stop. Since both the reports are since the reports were required to have been verified and thereafter either uploaded or forwarded to the concerned authorities, full stop, the district elementary education officer shall file an affidavit. The district elementary education officer and the block elementary education officer concerned shall file respective individual affidavits, bringing on record the number of students which the school had the enrollment that the school had on 9/12/2017, 2018, and 2019, along with the names and details of the students which were found present in the school on the date of inspection by the aforesaid authorities. The CRCC concerned who had uploaded the details in the portal in respect of the aforesaid years shall also file an affidavit along with the reports available with him, along with the details of the enrollment of the students who were found to be present in the school during his visit. Full stop. The petitioner shall also file an affidavit bringing on record the students who were present, who were studying in the school in the said years based on the records available in the school. Full stop. List this matter again on
11 Lord, same day Lord.
11th of March. 11th of March 2026. Full stop. It is noticed that the matter relates to provincialization of the school, and since there are discrepancies in the reports which give rise to litigation. Full stop. The authorities required to file the affidavits shall do so before the next date fixed. Full stop. Absence of affidavits may lead the court to draw up adverse inferences against the officers concerned. Let them not escape. You also bring one. Let us see. In the name of God. Yes, remember.
The 35, the government has filed affidavit. 36, my lord, is a case where the promotion has been not given. The 24, my lord, 11/24.
36
36, your lords will kindly say. 11/24, 19/11/24, that pays 32.
32. Yes, sir.
His gradation list, my lord, the petitioner pays 33, my lord. Sorry, page 33, Biman Bora, he is the petitioner here. And Nurul Islam, he is the private respondent. Your lordship will kindly see the date of promotion from to the UDA. That is, petitioner is 2008 and Nurul Islam, the private respondent, is 2011. So now thereafter they have changed fresh gradation list has been made, page 60. On the ground, my lord, the petitioner has been transferred from Dhemaji to this place.
At his own request.
No, as per things, as per this in public info. Base 60, your lordship. Now,
37 is another gradation list. We are not concerned with that.
yes, I'm
Apparently.
just showing shortcut, my lord.
Page 60, yes.
60, yes. Nurul Islam, now date of joining in the present place of posting is 2/7/2011. Date of promotion is 2011. And the petitioner has been shown at serial number 3. He is 2008. Admittedly, he is senior, UDA promotion. But now this has been done only on the ground because he has been transferred from Dhemaji to this place. This cannot be done, my lord.
Yes, what
Unless
is
it
the
is
basis?
a
Lordship, we
settled
have
provision.
received our instructions regarding this and we would like to file our affidavit as well.
Last time also they have taken
No,
time.
last time we
This
did not
cannot
have.
be done, my lord. Last time also they have taken time for
Lordship, we have
filing the
just received our
affidavit.
instructions yesterday. We'd like to file our affidavit regarding this. And there is
They
a
take
particular,
affidavit,
we will-
filed it.
In which case?
There
is another affidavit filed.
Item number 35.
35, the affidavit is filed.
Yes.
yes, Lordship.
Why don't we take up 35 and dispose it of?
No, 35 and because 36, my lord, they have, while 35 is pending, because that was because they did not complete the process of promotion. So in that case, they have said, my lord, this upgradation, that gradation list has been changed. So because of
So
that, they are
unless
not
we
doing it.
decide 36, we cannot decide 35.
35 and 36 is same, my lord. If your lordship decides 36, 35 also goes. Because 35 is only for the purpose of, my lord, they were just sitting over the, after holding DPC, they were not promoting anybody.
They held the DPC, they were not promoting anybody. You came to the court, they came up with a document saying that you are a junior person, you need
The
not be.
gradation list has been changed.
The gradation list has been changed, therefore we cannot promote and therefore.
So we
it
have
were
to
kept
challenge
pending.
it. We have to
So now
challenge
you
it.
are in 36. What is the instruction that?
Lordship, actually, from my side, the WBC number 1350, which is there, they had, they were aggrieved by the gradation list and the main ground as to why we selected Mr. Nurul Islam over the current petitioner,
Hmm.
we have specifically stated in our affidavit as to why that was so.
I mean, they have put.
And is also another ground is that the main petitioner who was there is actually junior, and the main gradation list which the petitioner is actually saying, which puts him in front of the Nurul Islam, which is here, that gradation list was never in force. They are saying that this gradation list was in force, so we have to follow that gradation list. But that gradation list was actually being misused.
So you had a provisional gradation list?
That also was not given into effect. That was
You had
never
a
given into
provisional gradation list?
No, that instructions I cannot say from my end like this. But so certain information is also there in our current affidavit, which we have specifically written in the 5275, for which we would like to file.
How much time would you require?
Lordship may give us 10 days time at least. If it is,
We'll
if it is
give him
not
10 days
inconvenient.
time.
Your lordship will fix the date. Your
We'll-
lordship will kindly
we are-
see
we are-
page 37.
Sir, we are fixing dates in every case. That is the general rule now. We'll fix a date for every case, a date on which we are looking into the subject matter before fixing a date without passing lengthy orders, only because we want to know on what day we can take it up.
Yes, I'll leave it.
The
to you.
contents of the other writ petitions,
Yes.
everything we are trying to keep in view. Now, will they allow them to file the affidavit in opposition within a period of 10 days? Have it fixed on a date. In case they do not file it within the 10 days, we will allow some costs to be imposed. So that the affidavit is
That
brought
would
on
be
record.
better, Malay, because from morning I have been sitting, they could have said that I want to file affidavit.
Lordship, that is not a particular, with all due respect, that is not a particular proper stand
It has
that
to be-
that he is
the
like the
secondary
senior
petition, my
counsel
lord.
is sitting. We are also
Secondary
sitting.
petition.
We are also doing our matters. I don't think that's a proper
In
stand. Lordship.
Assamese, there is a saying, kothate kota jai, kothate bota pai.
Yes, Lord.
Don't
Lord,
push it to a point of kota jai. You may be correct in what you say,
Yes, Lordship.
but then kothate kota jai, kothate bota jai. Is it none?
Yes, Lordship.
It is more important in the court to know when not to speak,
Lordship.
rather than when to speak.
Lordship.
Heard Mr. B.D. Das, learned senior counsel, appearing with the assistance of for the petitioners. Also heard Mr. So-and-so learned counsel appearing for the respondent health department.
Health department.
You are appearing for? Mr. You are for the private respondents, and you have filed your affidavit in opposition in both the matters. You have filed your affidavit in opposition. You have filed it. You have not filed it. Would you like to file it?
Second, I.
In the first one, you do not want to. Mr. So-and-so has submitted that he would not be filing any affidavit in opposition in WPC number 1350 of 2025. However, he would also like to have an opportunity. He would like to have an opportunity to file the affidavit in opposition in WPC number 5275 of 2025. Full stop. Although the learned senior counsel has put in objections on the repeated prayers of the respondents to be afforded opportunities to file affidavits. This court grants 10 days time to the respondents to file their response to the writ petition within a period of 10 days from today. The matter shall be listed again on March or 9th of March. On 9th of March 2026. By which time the petitioners may file their response to the affidavit in opposition filed by the respondents, if any. Full stop. It is made clear that if the affidavit in opposition are not filed within 19th, today is the 6th. Choose a date.
Lordship may say 20th of February.
20th of February 2026, the respondents shall, costs may be imposed on the respondents to accept any affidavit filed on or after 21st of February 2026. The order would apply to the private respondents also. Yes, you may file it, but to accept it will impose cost.
Lordship,
Yes. We have your affidavits ready.
It's their duty to fill up the post, my lord. It's their duty to fill up the post.
Bring on record the documents.
Well,
We
they will
don't need
bring-
elaborate arguments in the affidavits, do we?
They will produce the records, sir. They will produce the record.
The respondents may also supply the records to the learned counsel appearing for them to assist the court in adjudicating the matter.
Well, attempt for disposal.
Post has
Sir,
not written down.
Sir,
That I
that,
understand. I leave it. I leave it.
when to speak and when not to speak applies to me also,
I know.
not in all cases.
I understand.
Yes. Yes, sir.
Actually, here the petitioner is claiming Lordship the gratuity that.
You are asking for gratuity
Gratuity and the issue has been already resolved by the.
decided by this court.
Decided Lordship. And I have annexed the judgment also, and recently on that basis, this new judgment has also been passed.
Lordship, in that case, respondent number 5 and 6 has to be here, Lordship.
Name of the case?
Name of the case is Benuram Neuk, and I have already annexed one of the case.
There is one more case.
There is, I have annexed, I have
There
annexed.
is one more case.
Case 24. Upon
Hmm.
Chandra Gogo. On the basis of that judgment, only this judgment was passed.
Which judgment?
At page 24 of my writ petition.
Of your writ petition.
That's it.
Page 24 of the writ petition. Ah, this is what we were looking for.
Yes. And from page, paragraph 18 onwards,
Huh?
findings is from paragraph 18 onwards,
Okay, have you looked at page 27?
page 27.
Oh,
Page 27.
hmm?
Of the writ petition.
Of the writ petition.
It was another advocate, Mr. H. Grace Borwards.
The name reflects that, but I remember signing the wakalatnama. Anyway, it's decided.
Yes, decided. That's, and in terms
Just
of
tell us,
this,
madam, if it is covered or not.
Lordship, in
Yep.
that case, the Jyoti Chitraban, because they are the society under the government, they are, I think, name of the council is shown, Lordship.
Who is the council?
Some R Ali or
Section respondent number 4 and 5 का नाम लिखो इसमें.
5 and 6, Lordship.
Huh?
R Ali is shown, Lordship. So their response is very much required, Lordship. Otherwise, grants are provided by the government, Lordship. But as this is a society, so they have their own rules and regulations, Lordship.
but in the affidavit by the government, they have admitted in
And
terms
what
of.
about sitting on the
Lordship, that
fence?
I have seen, this is.
What about sitting on the fence?
He was not sitting.
Huh?
He was not sitting.
There was no fence or wall. You were sitting on the border.
That's it.
Mr. A.R. Tohbilla, Learned Counsel, appearing for the petitioner, submits that the matter is covered by earlier judgments of this court. The counsel for the respondent Jyoti Chitraban Society is not available in the court today. Full stop. Is this matter again on? 5th of March 2026, on which date the matter shall be considered for disposal. Respondents to ensure representation on the said date.
My lord, it's regarding carrying forward the internal assessment marks.
Hmm.
My lord, he appeared in 2022, and my instruction is that that marks is carried forward. So we may update the mark sheet regarding that paper 6.1.
So we are required to pass an order on that, or would you do it and we just record that you have done it?
My lord,
Nothing remains to survive, nothing remains to adjudicate.
Lord, within my lord, few days, my lord, we will update the,
We'll put it up in on the third week of March.
my lord.
Be done by then? Yes.
My lord, if it pleases my lord,
Ah.
maybe dispose, my lord, because my respected senior has already said that. Within a span of time, if they could do it, exercise could be carried out. It will serve my purpose
But
because
Mr. Swenson
I'm
and
kept in a
counsel appearing
limbo.
for the petitioner. Also heard Mr. P.J. Fugan, Learned Standing Council for the Guwahati University. Full stop. The Learned Standing Council for the Guwahati University has submitted on instructions that the relief sought for in the writ petition has been considered by the respondent university and the
Is
internal
being
assessment-
considered, my lord.
Huh?
That will be appropriate, my lord.
What?
Is being considered, my lord.
Is being considered by the respondent authorities, and they are not averse to carrying forward the marks of the internal examination
My lord.
with regard to the petitioner with regard to the
Paper
labor and
6.1.
industrial law paper, that is paper number
6.1.
6.1.
6.1 full stop. The learned counsel for the petitioner submits that the writ petition will be disposed of recording the submissions of the learned counsel appearing for the Guwahati University, which is based on instructions. Full stop. Accordingly, the writ petition is disposed of, directing the Guwahati University to incorporate the marks of the internal assessment of the paper number 6.1, namely so-and-so paper, by carrying it forward.
Labor and industrial law.
Labor and industrial law by carrying it forward. The petition disposed of no costs. We have directed you to carry it forward.
Well, if it pleases my lord, a time frame may be given, my lord, within which the respondent authorities may carry out the exercise.
We gave it to you like this. You wanted an order like this.
Yes, my lord.
We said we will have it listed in March, by which time they will come with the record. You said, please dispose it off. So I was fixing it in March for their assessment to be on record. Yes, next. Huh? Who is respondent? Bar council. Yes. Correspondent number.
Obliged, my lord.
Obliged. We are awaiting instructions in this case also.
What is the grievance?
Grievance is that in this petition, we have challenged the select list of published on 17/8.
On what basis?
On the basis that it is suffered from biasness.
How do you know?
It is, my lord,
Why should we?
I have
should-
annexed the select list at page 86.
Huh?
Page 86.
Uh,
Here only rule numbers have been published, no cut-off marks. Marks obtained by the all the candidates have been published in their website. So how can a candidate know that how his
individually go through your admit card, you will be told what marks you have.
no, there is totally it is not transparent. There is no any marks uploaded in their website, and when we applied for OMR sheet through RTI, they have said that we are not providing you any reply. You have to come through a organization, or we
Where
are
is
not-
that? Where is that?
Th-
Where is
that-
that reply?
that is verbal submission. That is verbal submission. So this,
RTI applications cannot be verbal submissions. You have to give
my,
a
my lord,
IPO, you have to send it to the address, matter ends.
my lord, I will bring in record who are
You will
the-
bring on record.
Yes, I will bring in
The
record.
counsel for the petitioner prays for some time to be allowed to bring on record certain documents which would
Certain
facilitate
documents.
the
Yes.
adjudication of the matter. Accordingly, he is granted 3 weeks time to bring on record the additional documents. Since the additional documents are proposed to be filed in the matter, the respondents would be required to respond to the same. Therefore, advance copy to the respondents before filing the additional documents list again on 13th of March 2026, allowing time to the petitioner to file their documents.
Okay. In the meantime,
In the meantime, what? You will file your affidavit.
no, we'll wait for the doctor. All right.
Yes.
But a constable appointment, my lord,
Hmm.
belated, my lord, certificate was issued. my lord.
Belated certificate.
Yes, my lord.
Who issued it?
The deputy commissioner has, my lord,
Prabir Kumar Ghosh, dismissed. Prabir Kumar Ghosh, Union of India versus Prabir Kumar Ghosh.
Lordship, here, Lordship, their NCL certificate was lately submitted. As on date of last date, they doesn't have the qualification. NCL certificate.
Union of
Yes.
India versus Prabir Kumar Ghosh. If the OBC certificate is not produced on time or it is not within the time frame given in the advertisement, then
OBC certificate.
then
OBC certificate
not
was
in the-
given, my
not
lord.
in the format given.
Only non
Non-criminal
criminal certificate.
Sir, without a non-criminal certificate, OBC certificate is a what? Piece of paper.
Paste, my lord, Kali Peruzol, it's page 57, annexure 8, my lord. Annexure 8 page 57.
Yes,
Deputy Commissioner issued this letter, my
right
lord.
now, court number 10
What
has
did,
dismissed.
huh?
With refer-
Right, court number 10 has dismissed.
Dismissed.
With reference to the subject
But-
stated above, I have the honor to inform you that the
Hmm.
following candidates who had appeared the recruitment so and so, Guwahati, Assam is requesting for backward NCL OBC annexure certificate. And name of the candidate so and so, Rituraj Das. The candidate is presently being rejected for non-submission of OBC and non-criminal certificate prior to the date of filing application 14/10/24. The candidate has intimated that the examiners of the recruiting department are asking for NCL certificate prior to the last date of application 14/10/24. In this case, it is pertinent to mention
Sir,
that
it will save us a lot of time. We are trying to adjudicate matters in the shortest possible time. So kindly cooperate. Union of India versus Prabir Ghosh. Go through it. Can we entertain the writ petition is? What will be clear? There is, there are 47, there are 37, 47, 37 something. This court had allowed on certain occasions, saying that it is not in the hands of the candidate
yes, my lord.
as
It
to
is
when
deputy-
the certificates will be issued by the deputy commissioner once we apply. And therefore, once a man belongs to a non-creamy layer, today he was a non-creamy layer, yesterday also, it will only change, can change in the future, not in the past. Supreme Court said nothing doing. You don't have a certificate, sir, you
But
don't have a
But
certificate.
deputy
sir.
commissioner, he has mentioned that his pair should be considered.
2024 and 2025, the dates. Have you seen the dates?
Yes, yes.
Then you wanted something in 2024.
Hmm.
Someone is certifying now that our machine is not working, I can't give it today. It was required to be done in
And
2024. sir.
deputy commissioner also observed here, my lord.
Okay, give me a printout of Praveer Kumar Ghosh. Let's settle it now. Heard Mr. H. Das, Lieutenant Counsel for the petition. Shall we dictate the order? Or would you come back with Praveer Kumar Ghosh?
Yes, I will come back.
Look, list this matter again on
Any date subject,
your
to-
convenience.
I have nothing. Any date subject to lordship conference.
13th, Lordship.
Hmm?
13th.
13th of March 2026. Allowing Mr. H.K. Das have instructions in the. You have filed your affidavit.
No, Lordship.
Mr. S.S. Roy, Learned Counsel, appearing for the Union of India, shall ensure the affidavit is filed on or before the legislative list. Absence of response
Lordship.
may entail
Lordship. Lordship.
adverse
figures
inferences.
March. 14th.
March, yes.
There on, na?
42, yes, sir.
Lordship.
Alright, in this case-
Today I filed my affidavit, Lordship.
Just I have received it. After 2 weeks.
Mr. Islam, Learned Counsel, appearing for the petitioner, has submitted that he has just been served a copy of the affidavit in opposition and would require some time to address the response taken up in the affidavit. Full stop. List this matter again on, give us a date in March.
After 2 weeks,
March
March, first week,
9th,
obvious,
first day of second week, 9th.
obvious.
May it be the lordship. Since this is prolonged suspension, petitioner was petitioner was
Any review done, madam?
lordship?
Any review done?
No, lordship.
There is an affidavit. When were you arrested, ma'am?
I was arrested, that I have an extra,
Give us the date. We will not be able to go through papers if we keep. going
yes,
through
lordship.
papers. Ah, 39.
1/10/2023. And placed under suspension,
Not 110, madam.
10/10.
I think it is on 39. Please come to page 29 of their affidavit. Next, Shari. Arrest is on 39 200. 2023.
Lordship, page 19 is my bail order. that I have annexed to
Where
this
is it?
page 19. The petitioner was detained in jail since 1/10/2023. So that is the date of his arrest. Pursuant to date of his
Please
arrest.
read page 18 before that. Can you have page 18?
Yes, Lordship.
Yes, the second last line of the first paragraph. Directorate of Vigilance and Anti-Corruption Department on 39/2023. You were arrested on 39/2023, but you were remanded to
He was in
custody
jail since
in on 110. So your
110.
date of arrest is 39.
13.
Yes, in your affidavit of
This
petition, it is stated.
deemed suspension, Lordship, and thereafter, after coming from, that means,
When were you released from custody?
This order, Lordship, petitioner has been released. That is
Yes,
on the
and when-
19/10/2023.
And when did you inform the department?
Subsequently.
When? 90 days will start from there.
Lordship, yes, it was in the writ petition, it's a page 21, Lordship, 9/11/23, Shokos was issued.
That is okay.
Yes, Lordship.
Chocos can be with the information this is released or without the information that he is released. We want to know when did he inform?
Nothing.
Writ
In the
petition.
writ petition.
But then he
nothing
has
is there.
replied to it. What does his reply say?
Reply also
Just a minute.
not that clear, Lordship.
Lordship, page 22, my reply. 24/12/2024.
You appeared
Petitioner
before the
repeated.
authorities. You appeared on it, applicant man.
Lordship, kindly take it up on next week, Lordship. I shall get the updated status, Lordship, what actually has happened. There are many cases, Lordship, that inquiry has already been submitted, Lordship,
If you come to page 23,
23.
something very para 2. Departmental inquiry was instituted by order dated 9/11/23.
9/11/23,
And
yes.
then in the next paragraph, he says, I have appeared on 8/10/23 in the inquiry.
Lordship.
1 month before the inquiry
Lordship,
started.
something there, Lordship, that also I have gone through, Lordship. That's
Then
why,
order hearing on 30/11. Madam, get your dates correct.
yes, Lordship.
Get your dates correct.
This is a Lordship. I can't help
No,
because
no,
this is
you
submitted by
you would have
submitted
a-
by the petitioner
you would
himself.
have a
Lordship.
you would have a petitioner. You know the petitioner. Ask him, give me the dates. Give me the correct dates as of today. I have to give it to the court.
Meanwhile, Lordship, let them place the.
We don't
proper-
burden them. We don't burden them. Not when your data is not correct. We'll have it listed again on February February due. Short order.
Lordship,
Refresh query soon.
fix a short date.
Oh yes, 25th of
Anyway, no
February.
issue.
25 February.
No.
Ms. T. Som, learned counsel for the petitioner, has submitted that the petitioner was arrested in connection with the police case on 39/2023 and had been granted bail by the order dated
19/10, Lordship.
19/10/2023, full stop.
There's a
The
mon-
counsel for the petitioner has submitted that
I think it's.
the learned counsel for the petitioner has submitted that there is no review of the deemed suspension of the petitioner, although a show cause notice had been issued to him. Full stop. The learned counsel. Oh.
Yeah, great. Next week, Lordship.
Just a minute. 1/10/23. Yes, we will need the date.
Next
will
week,
need the date.
Lordship. Lordship may post it on next week. I'll get the, it's 2-3 dates. I'll get it, Lordship.
Just a minute.
If he's entitled, Lordship.
Someone seems to be up and doing. Yes, madam. Next week, 11th. On 11th, kindly calculate the dates, madam. You see, there has been extensions. Is it not?
Not yet. Extended 3 months. It is there
So
on
the date on which he was actually released on bail, The date on which you were informed about the release on bail.
Yes,
Those
Lordship.
dates will be very
Yes,
important
Lordship,
because
this
there is an
needs
extension.
To be ascertained, Lordship.
You have to give us the date on
Yes.
which you were released on bail. And you have to tell us the date on which you informed the department that you have been released on bail. Go through the judgment of Santosh Kumar versus Union of India. Calculation is given.
Lodge.
Every calculation is given. If you fit in the calculation, you have a case. 11th of
11th.
February.
11th, Lordship.
Obliged.
Learned counsel for the petitioner shall apprise this court the date on which the petitioner had been released on bail and the date on which the information of such release had been given to the department with requisite proof. Get some receipt copy.
Lordship.
Deeply obliged.
Lordship, kindly grant 3 weeks times for filing the substitution petition. As we could not
Who
communicate
do you want
the
to substitute, madam?
petitioner.
Petitioner is no more.
Yeah, petition is no more.
So why is the substitute?
The legal hires.
No. If the petitioner is expired, substitution, there is a certain time frame.
We could not communicate with the legal hires of the petitioner. That's why.
Maybe they don't want to continue. Yes.
For respondent, Your Honor, the respondent, Ramendranath Sharma, he is also retired.
So, did he do something when he was in service? That is contempt. If he did not do anything while he was in service, not good news for him. What was the order? We cannot continue a case like this with a deceased person's name on record. On the last occasion, we had already recorded that you know about the demise.
Yes.
From the knowledge of the demise, there is a certain time frame.
We couldn't contact his legal hires.
Huh?
We could not contact his legal hires.
The learned counsel for the petitioner has submitted that they have not been able to contact the legal heirs of the petitioner. Which step? Is this matter again upon the application to be filed for substitution of the petitioner as had been paid for by the learned counsel for the petitioner on the next date. Since the petition counsel for the petitioner submits that they are not in touch with the legal heirs and no petition has been filed, no date is fixed in the matter. You file your application, it will come up as and when. Yes.
Okay.
Wait, please, Your Lordship.
Hmm.
My lord, this matter went for mediation, my lord, but mediation failed, my lord.
Who did not appear? You did not appear or department did not appear? Non-starter. Could not even start. Both parties are not present. You didn't, your client?
It's a formal party. It's against the PW department. What had happened, he had taken loan from us. So there was an undertaking, my lord, that it will be recovered from his salary. That was not paid. So, my lord, the PW, we wrote to the PW department. Then they were just issued several letters saying that you pay the money or the pension will be stopped, etc. my lord. That's why he's challenged all those letters. We are just similar formal party here, my lord.
Aparna Devi. What do you want today?
My lord, it may be listed on admission column, my lord.
When the counsel for the petitioner submits that the matter has been, that the mediation in the matter has failed, therefore he prays that the matter may be taken up for admission on another date, list the matter again on 10th of February 2026 in the admission column. Aparna or Orpona? Aparna Devi. Similar situation, CRPF person took a loan, court said without a court order, nothing doing.
So actually,
Pension.
we are seeing against the department. That's why we just filed an affidavit indicating that he had taken loan from us, nothing more than that.
Your recovery would be against the estate.
We have already filed a money suit.
There you can have a order, but Can it be stopped? Who appears for the PWD? Who appears for the PWD? None. None appears. It is noticed that none appeared for the PWD during mediation and none appears in the court today. Yes.
I'm obliged. May it please your lordship. Lordship, I am appearing on behalf of Mrs. R. Chaudhary. Mrs. R. Chaudhary. Kindly some time may be given for filing the rejoinder affidavit to the affidavit opposition filed by respondent number 5.
2023, the affidavit in opposition. 3/12/2025, court is told that you are newly engaged. We do not have mercy on them when they say we are newly engaged. Why should we have mercy on you? Yes, sir, you are functioning without an Anganwadi worker.
Lordship,
You are functioning without an Anganwadi worker and you are not interested to file a interim
Lordship, we are filing our affidavit on Monday, Lordship. It's already ready.
affidavit in opposition filed by the respondent number 3. Who is 3?
3 will be.
Who is 3? Oh. You are appearing for whom?
We are for the BTC, Lordship.
Hey, Mr. Das, we expect you to be more conversant with the parties at least.
Lordship.
Huh?
Lordship, but
Who is 3? BTC.
please BTC itself, Lordship.
3 has filed.
We have sent one affidavit to be signed.
Another affidavit.
Lordship.
Get it signed by some other respondent then, not by 3. Learned counsel for the petitioner has submitted that they may be allowed to file a rejoinder to the affidavit in opposition filed by the respondent number 3. Prayer is allowed. List the matter again on March 16th of March 2026.
Service of private respondent is not completed. Let them take the fresh steps regarding the upon the respond number.
9/12, you were required to stop petitioner. You were required to take steps for service.
Yes, lordship, it is.
And you do not care to appear before the Loazima court, huh?
Even then, there is an appeal provision.
Also, lordship, I think read
What is the appeal provision?
162C,
Regarding what?
my lord, that Gaon Pradhan, my lord. There is a-
Some of the cases have met a very dismal fate some time ago, this Gampura appointment.
Lordship, so my
1 or
lord,
2 cases survive. I think there was a whole bunch, 1 or 2 survive.
let them file the appeal before the.
All of them have gone for an appeal if I'm not wrong.
Lordship.
Well, in this case, liberty may be given to us so that we could approach the.
You are under instructions to make that submission?
Yes, my lord.
Huh?
Yes.
Otherwise, you have instructions that you can go for an appeal. The
Yes,
petitioner
yes.
has told you.
Liberty may be given to us.
Heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard Mr. J. Hendrik learned counsel appearing for the.
Respondent one, Lordship, I appeal.
Respondent number 1, Ms. M. Bhattacharya, learned additional senior government advocate appearing for the respondent number
2 and 3.
2 and 3. None appears for the respondent number 4 since the service of notice. Since notice is, since petitioner did not take steps for service of notice upon the said respondent, full stop. Today, the learned counsel for the petitioner, Mr.
Sri Sharma.
has made a submission that he may be allowed to, that he would not, that he is under instructions not to press this petition in case the petitioner is allowed the liberty to approach the appropriate authority under
162C
of
executive instruction.
the executive instructions to file an appeal. Full stop. The learned counsel for the respondents do not object to the said liberty being granted. Accordingly, this writ petition is closed, granting the liberty as sought for. Writ petition is disposed of.
Deeply obliged.
Yes.
Lordship, give a time bound, Lordship, that it is earlier, but it
The
is.
appeal may be filed within a period of 45 days from the date from today.
Lordship.
Deeply obliged.
May I please your lordship? Lordship, I am here on behalf of Standing Council of Animal Husbandry and Veterinary Department, MM Kutoki. She has to leave the court because of high BP. Lordship, kindly adjourn the matter for the day only.
Who had to leave?
Standing Council of Animal Husbandry and Veterinary Department, MM Kutoki.
But one thing is there, the note. The note,
That's to send an intimation to that.
a report has come. Petitioner is. The process server report states that the petitioner has passed away as informed by the people of the locality.
I think now never the legal hairs also, so maybe.
Hmm? The office note dated 22/1/2026 reflects that the note of the process server who had gone to serve the notice or notice as directed by this court on the petitioner has reported that the petitioner is no more, and therefore and that no one agreed to sign the notice as a witness, full stop. There is no representation on behalf of the petitioner since the counsel for the petitioner had on earlier occasion submitted to the court that the brief had been withdrawn by the petitioner from the counsel, full stop. In view of the circumstances, this writ petition is closed. With the observation that in the event the legal heirs of the petitioner intend to re-agitate the issues raised in this writ petition, they would be at liberty to file appropriate application for revival of the writ petition. Writ petition closed on the above terms. Please record the presences. From Ms. N. Kothari. Madam appears for respondent number. Yes, sir.
My lord, we have already submitted our aggrieving reply. And hence, for admission, that may can be fixed.
Ms. Kotogi is not here, na?
Same prayer, my lord.
Heard Mr. C. Dekal and counsel appearing for the petitioner. Is this matter for admission? Is there any urgency in the matter, sir?
Has your lordship is there, my lord?
Is there any urgency in the matter? Any particular date?
There, my lord.
On the 16th of March 2026, 16 March 2026. Yes, next.
Much of this.
Name of the book is shown, my lord. Name of the.
Minimum of the what was the order required compliance?
309. Order to it was page 36. Petitioner, my lord.
Minimum of the pay scale. Give us the operative portion of the order, sir.
He, my lord, retired as Khalasi, my lord, from the Department of PHE, and he has not granted the pension.
Is it page 36?
Yes, yes.
Operative portion is at page 36?
Yes.
Yes, sir.
Lordship, here
He is an employee of the
PhD.
PHE department, Lordship. Now, whether,
You are for the finance.
yes, Lordship, now,
Is paying for the PHE?
then whether,
What is the name of the particular person? PHE is Ashok Kumar Chaudhary and Amitabh Chaudhary and Kailash Karthik. Respondent number 1 is
pensionary benefit ko padega.
item delivered to PHE
Yes.
for A2. Who is A2? Who is A2?
Chief engineer, Lordship.
66. Kailash Karthik. Item is dispatched. 85. Respondent number 2 has received it.
He's a chief engineer.
And this is what you should be doing, sir. 71.
Respondent number 5, Lordship, I am appearing.
Item delivered. Just a minute. Respondent number 3 received. 2 and 3 received.
Yes.
Received. And you are appearing for
I am
Yes,
appearing for
five.
respondent 5.
finance.
Yes, Lordship.
AG none appearing. Are anybody for PHE here? No.
Mr. Gogoi was there, Lordship.
Huh?
They were here, Lordship, but
Okay, the postal journals have been made part of the records by the office note dated 4/2/2026. List this matter before the Loazima court to determine the service of notice on the aforesaid respondents. On the respondents, not aforesaid.
On the other respondents, other respondents, 1 and
On the respondents, all will pass in. We have been given item delivered to PHE, whether it is enough.
or not.
Let a report come. হৈ গ'ল? It does. If you আগতে কৰিছো বুলি মনত আছে। Yes, sir.
Lordship, in the morning, I was made mention for adjournment.
What? Tell us again.
Lordship,
You need a,
engaged council members is out of.
you need a substitution. No,
There
improvement.
there is a-
Improvement of whom?
There is
No.
3 IA, my lord, 1 for substitution and 1 for implement of party and 1 for condonation of delay.
So unless your delay is condoned.
Yes, madam.
In a contempt petition, why do you need condonation?
Lordship,
Your item number which? Will you be appearing, Mr. Gogoi, in the earlier item? তিনিখন আই দিয়কচোন। Delay in filing what? Substitution, yes, but what is the Supreme Court judgment? If you pray for a substitution, you
today
don't
I
need
was,
to pray for delay. You don't need to pray for condonation.
Lordship, today I was only instructed to adjourn the matter. I am not engaged council member.
উল্টা order. Let's option. Report will down.
After the. After the. Most of. Most of.
In item 53, Malana thread is appearing for respondent 1 to 3.
Yes, my lords, I can take notice.
53.
3 minutes. Then can I come from code 10, my lords? Yes. All right.
But office note indicates that respondent number 7, no notice was issued. Actually, respondent.
This paper 5.
It is 5.
55 lordship.
ভুলতে 1 to 6 লৈ কৰিলে একো ৰইলে নাই অফিস নোট কম 7 ত এপিয়াৰ কৰিলে আৰু তাকেইটো মানে 7 you will appear my lord. I think by mistake it was left my lord. Malay respondent number 1 to 6 notice has been issued. I have checked the file, my lord. Yes, miss. Office note 19/12/2025 indicates. No, today that.
Now, in this matter, a coordinate bench has passed under the judgment, my lord. I have gone through it. Yes, my lord. Yes, yes. My lord, from the point of view, the relief claimed, it is covered. But the pleading part is different because we have different pleading. We have submitted before the honorable court the advertisement on the basis of which we were appointed. My lord, here the basic question is that whether the petitioners were appointed by the duly constituted selection committee or not. And for that, my lord, in our matter, my lord, since 2023, my lord, since September 2023, my lord, the honorable court is directing the respondent authority to produce the record on what basis we were appointed, whether we were appointed on the basis of duly constituted selection committees or not. To determine that issue, my lord, the records are being called for since 2023, my lord. So in that matter, my lord, I have gone through. There was no such order. Even I have gone through the orders also. No records were called for. And even in the judgment also, my lord, I have gone through. Nowhere it is written that the records were called for or records were necessary. So, my lord, that is the point of view, my lord. My lord, yes. On that perspective, my lord, it is not covered by because the records are being called for and records are the basic things on the basis of which the honorable court will determine the issue. Yes, my lord. Yes, my lord. Yes. Yes, my lord.
Lordship, first of all, there is a order of the my lord Justice M. Buzur Burwa. That just my lord Justice Buzur Burwa's orders is there. My lord may kindly go that particular order. Before that, lordship, just petitioner have to clarify whether he was appointed under TF or not.
Of course, we were appointed in the.
Then, lordship, this order is clearly covered. When TF appointment is done, lordship, my submission is that record is not required. Lordship, that is the reason, lordship.
No, my lord.
Nothing is there.
Selection in the sense that, my lord, on my 3F appointment order is at page 17, my lord. 17, my lord. Annex 1A.
Let him place the advertisement as well as everything, lordship.
Yes, my lord, I have.
Everything the record, lordship. Record, lordship. When TF appointment is made, Lordship, that is
I-
that is the reason, Lordship.
My
That
lord,
particular judgment is usually covered, Lordship. We are go by that
This-
judgment, Lordship.
Appointment order, my lord, page 17. It was issued by the Deputy Secretary to the Government of Assam, Education Department. It was dated 9th June 1992, my lord. And my lord, regulation record about our appointment under regulation TF. They are saying that it was not by the duly constituted selection committee because this case is particularly for a benefit under CAS, Career Advancement Scheme. Yes, my lord, their judgment is also there, but their
So
judgment
many
is not
judgment is
related
there,
to
not only
this
division
CAS
bench,
benefit,
Lordship.
my lord. No, my lord. My lord, my submission is that I have also gone through that judgment, my lord. Not only one judgment, 2, 3 judgments are there, my lord, I have seen. But the thing is that, my lord, those judgments were regarding regularization. Here we are not claiming the regularization. Page 31, my lord. Yes, I am claiming, my lord, the benefit under CAS, Career Advancement Scheme, my lord. This is a scheme, my lord, that page 31, my lord. It is a part of my lord, is a notification, my lord, annexer 6, page 31.
We will file it. There is no difficulties filing, Lordship. But Lordship, the concept of TF appointment is, Lordship, go beyond that, Lordship.
My lord,
Even, Lordship, the Supreme Court, Lordship. Lordship. Lordship.
Yes,
But
my
with
lord.
that,
Yes.
Lordship, that part, ad hoc part cannot be continued, it cannot be counted for, Lordship, that part. That was decided by the single bench, Lordship. As well as Supreme Court decision judgment, I will place exactly the cash, Lordship.
My lord, I'm
Cash
sorry to
benefit.
say,
Benefit of cash, Lordship. Just now I am showing, Lordship. Just now I am showing, Lordship.
my lord, I'm sorry to
Yes,
say
yes, sir.
that the affidavit
Let
filed by
him
the
finish, Lordship.
respondent, my lord.
Otherwise I will stop, Lordship. Let him finish,
No,
Lordship.
no, no, if
Let him
this
finish,
open it
Lordship.
up, no issue.
Let
I'm
him
just,
finish.
my lord, the affidavits filed by the respondent, my lord, they have not even mentioned that we were served continuously. We served
When he is serving,
continuously.
Lordship, 100 years
They-
continuous service, then also he is not entitled in the cash, Lordship.
No.
Our rule said, Lordship.
No, no.
If
There
he
is
is,
no
if he
such
is
rule.
serving 100 years also not entitled.
No such rule, my lord. Only 1 year is sufficient, my lord, as per rule, my lord.
Lordship. Lordship. 100 years also he is not entitled, Lordship. I am saying 100 years, Lordship. I am saying 100 years, Lordship. No, Lordship. Paragraph 29, Lordship.
My lord,
Eh,
that
It's
is
a
why, my
different
lord, in
Supreme Court judgment,
2021 also a hearing was there, my lord.
Lordship.
It will be ultimately 100 years.
Sorry. Lordship, we'll do, Lordship. Everything is covered. His judgment also reiterated in the judgment, Lordship. Lordship, no issue, Lordship. No issue. Lordship. Lordship, I'll file. Lordship. Lordship.
Much obliged.
If we go by the order, Lordship, we will go by the concept of TF, Lordship. Nothing is required. I will file it, Lordship. I'll file. Lordship. There is order, otherwise, my Lord Justice Buzurba's order may also go for whether he has gone to the office or not. That part asks, Lordship. He put by way of affidavit.
No, 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 no.
By
What is the
order
reason
9,
of
Lordship.
my going to the
What
office,
was
my lord?
observed by the honorable court, Lordship?
My lord. Say. Oblige, my lord.
Even Lordship, court's clear observation is there, Lordship. My Lord Justice Buzurba's judgment. My Lord may kindly go to only that particular order, not judgment.
Oblige, my lord.
Oblige, Lordship.
May I please, Your Worship? My lord, Mr. Sharma on legs in court number 4, my lord. In this case, my lord, notice has been served upon upon the respondent 1 to 6. 7 has not been served, my lord, as per obvious note. Therefore, 7, my lord, BTC, my lord, PCT may take the notice, my lord, on behalf of respondent number 7. On move. Ziu Ahmed on behalf of N. Sharma.
Bintere, sono Bintere. Questo non Bintere. Sorry. Lordship. Deeply obliged, Lordship.
Yes.
My lord, I have placed the report, my lord, and there is a green flag mark, the resolution taken by the new resolution taken by the committee. Yes, ma'am.
They have not said they are putting up their marks or not.
Yes, yes, my lord. I have seen they are actually they have again sent the name of the private respondent, my lord. On yes, madam. That has to be asked to review in terms of my lord, this OM, because in OM doesn't say
Teaching
anything-
experience.
anything regarding teaching experience for. Sorry. Yes, yes, yes.
You will see whether there is orders of this court is clear on
The college authority, my lord.
Yes.
Yes, yes. Yes. Yes, ma'am. Otherwise also, my lord, the main director has to take a call, my lord, either to reject or allow, my lord.
No, as per the office memorandum.
Yes. Yes, that's true, my lord.
times in this court, yes, with the submission.
Yes. Yes.
So if you take a day,
Yes, ma'am.
this court, the problem.
Yes. Yes, ma'am. Yes, ma'am.
And people often on.
Yes.
Each is helpless.
Helpless,
because
yes.
there's no discipline.
Yes, that's true.
This is a position where the matter is
Yes, ma'am.
each ensure that we are given direct people at the judicial power.
Yes. Yes, ma'am. Yes, ma'am. Yes, ma'am. Since they have not appeared, ma'am.
Exactly, and they are supposed to. Exactly.
Yes, yes. Yes, madam.
Yeah.
It's the third time they are.
Says you're trying to delay the adjudication.
Yes.
Hinder the adjudication.
This is the third time, madam, they are sending the same name.
Indeed, it's same.
Yes.
They're not. They're not.
Yes.